Chapter 5, Intellectual Property. We're going to look at what is intellectual property, why the protection of intellectual property or trademarks is important, and how does the law protect patents, what laws protect authors' rights, which would be copyright, and what are trade secrets, and what laws offer protection for this form of intellectual property. We'll also look at how the internet has changed intellectual property. So ponder this statement. The internet is just a world passing around notes in a classroom. We're going to have a classroom discussion discussing that. This was actually meant as a joke. Let's see how much of a joke it really is. So let's get on with this intellectual property. By the way, it's snowing out, so it's quite nice. So what is intellectual property? According to the book, it's any property, and this is a key word, property, resulting from intellectual creative processes, the product of one or more individuals' mind. And this was such an important key concept that the U.S. Constitution recognized this and wanted to protect and promote intellectual property. And you can find it in the Constitution, Article 1, Section 8, and that empowers Congress to protect it. And in 1940, this became a little more important simply because of all the inventions occurring and so much progress being made so quickly. It finally came up with to promote the progress of science and useful arts by securing limited times to authors and inventors the exclusive right to their respective writings and discoveries. In other words, wanted to protect the fruits of thought labors, or people who were very creative in their minds and with creating inventions and concepts of progress. So intellectual property, what is that? The laws protect patents, which are inventions, protect trademarks, which designate a company that we associate with. Think McDonald's and the Golden Arches. And it protects copyrights that protect writers and people of plays and music and resources such as that. One way to be able to use a copyrighted item or a trademark or a patent is to get a license for it. And that would be an agreement between the owner of the patent, the copyright, or the trademark that would permit you to use that intellectual property. And usually it's limited in time and in purpose. So basically, this is what we're going to look at. What is not here are trade secrets, which is a bit of a different category, but it still falls underneath intellectual property. So here we go. And this is an example of intellectual property and the protection of intellectual property, and an example of tort action or civil action in court. And it's the typical Apple versus Samsung. And this has been going on for, 4 years now. Originally, and just take a stroll with me here. Originally, Apple and Samsung were working partners, and they still are, believe it or not. And I think it was about 2010-11, Apple said, wait a minute, Samsung, your stuff looks an awful lot like the iPhone. We think you are using some of our patents, and we want you to buy a license from us. And probably that would have worked, except Apple wanted $30 a phone and $40 a tablet, which meant for every phone that Samsung sold, it had to pay $30, or every tablet, it had to pay $40. Now, Licenses at the time were going at about $5 a phone and $5 a tablet. Samsung said, no, we're not going to do that. That is not fair. So then the suits started evolving, claiming design copy, etc., etc. That was from Apple. Samsung countersued, claiming that it was a standard essential patents they were using, and standard essential patents are patents that are needed to promote that particular concept, such as computers. There are standard essential patents that you can legally license for a very small and fair fee, which is what probably should have happened right up here, but didn't. So, by maneuvering of both sides, there eventually were 30 suits filed. Settlement talks were ordered, arbitration and mediation, in 2012, and they absolutely went nowhere. Finally, in the United Kingdom, Apple publicly posted Samsung did not copy any of their patents in the United Kingdom or in England. So that fairly well settled that particular suit. Then in, I think it was about 2012, again, the U.S. trial started. By the way, these suits were all over the world. There were over 50 suits now worldwide between the two of these. And the U.S. trial came back and said, verdict to Apple, Samsung owes you $1 billion. But the injunction was lifted off of Samsung's Nexus so that they could sell that in the U.S. Apple patents were called into question in December of 2012. I believe at about this point here, Samsung also countersued or filed for an appeal. There were some patents for Apple called into question in December of 2012, and the talk was that this could trigger a retrial of all the previous, and the verdicts of the years past would be put aside. Samsung, in the meantime, continues selling all the products in question. Came back, they relooked at the verdict that was given up here, and they found that that verdict was calculated incorrectly, and a retrial was needed for the correct calculation, and that was June of 2013. Where are we now? Then in August of 2013, the International Trade Commission, the U.S. International Trade Commission, found that Apple violated patents belonging to Samsung. So here we go again. The above ruling was vetoed, and now some of Samsung's products are banned. So there's the retrial of the damages up here came up with an amount of $290 million. And that was in November of 2013. Again, Samsung files an appeal in March of 2014. The second trial, now, Apple is asking for $2 billion in April of 2014. Suddenly, in August of 2014, Apple and Samsung dropped all of the lawsuits outside of the U.S. and only let the U.S. lawsuits stand. Then around December 24th, 2014, Apple lost a very important round of suits concerning their pinch and zoom patent. And as of this date, things are still moving along, especially in the United States, with lawsuit. Now, the question becomes, and this is something we're going to talk about in class, how good is all this intellectual property protection? Is this stifling creativity? How much money has been wasted in the courts here? And has anything actually been proven? Is it time for intellectual property to be revisited and for a recalibration of some of the protection for intellectual property? We're going to kind of look at this week. So here's a question. Select all that apply. Which of the following are considered intellectual property? The patents, phone books, they're written, copyrights, common knowledge, scientific discoveries, or trademarks. Now moving along, let's kind of look at trademark protection. And a trademark is a very distinct motto, mark, device, emblem that a company manufactures. What do I want to say? Not manufactures, but that a company designs that will be a visual representation of their company, and they put this on all their products. Once it's established, it is for exclusive use by that owner who created it, and it can be established in a couple of ways. You can register it with the U.S. Patent and Trademark Office, or if it's used prior enough, it becomes common law protection. And we'll have a video kind of about that common law as we go through discussing some of these things. Trademark examples are Coca-Cola, Starbucks, and McDonald's. What do you think of the first thing that you think of when you hear Coca-Cola? How about Starbucks? There's an emblem that comes to mind. And of course McDonald's, it's the golden arches. These are all trademarks, and they're all registered trademarks. Now there can be violations of your trademark. Somebody can take a trademark and change it slightly and say it's their trademark. And this is called trademark dilution. And if it's a trademark that is very similar to, say, Starbucks, they can actually be taken to court and told not to use it. There's an infringement where you might want, where somebody simply copies it, the trademark, and that causes confusion with the customers, and it's also fraud because you're using another company's reputation. You have to be able to differentiate between competing products. Now there are different kinds of trademarks, as far as degrees of trademarks. A strong mark is a fanciful, I know that's a silly way of describing that, but this is a trademark that's created for the sole purpose as a trademark. It just is. You have Exxon, you have Kodak, Xerox. Those are what you would call fanciful, and they were designed specifically for those companies. There's arbitrary, which means a common meaning but no relationship to the service or product. Apple computer. And Apple has nothing to do with a computer, so they just selected an Apple. Lotus has nothing to do with spreadsheets, and Sun has nothing to do with MicroSun. And then there are suggestive, and these trademarks, such as Microsoft, Netscape, and Silicon Graphics, slightly suggest what the product is about. Microsoft, computer software. Microsoft, computer soft. Netscape is using landscape in the net sense. Netscape. And Silicon Graphics, again, graphics related to computers. Silicon Valley graphics. There's descriptive, which would be your 104 keyboard, obviously, right? And then there's generic, and a generic comes from public common use. Kleenex. There really is a company called Kleenex that has a trademark for the Kleenex facial tissue. Then a descriptive mark or a secondary meaning, which is descriptive terms, acquires a secondary meaning when the consuming public associates that mark with a particular producer rather than the underlying products. An example they give in the book is Holiday Inn has acquired a secondary meaning because the consuming public associates that term with a particular provider of hotel services, not the hotel services in general. So, trademarks, many kinds, and different ways of looking at them. Here's a question. Protecting a trademark, this is true or false, is important so that the meaning and the association of the trademark is with the original company's product, not confused with another company's product. And other trademarks that are called different things, there's service marks, and that's a trademark or a service mark that is related to services. Examples would be FTD, AT&T. How would you like to buy flowers from somebody who is using the FTD service trademark when they really weren't, and you were under the impression that you were going to get the good services of FTD and didn't? That's sort of an example of how important service marks are. There's a certification mark, and you'll see these all over the place. UL tested, every time you plug something in, you see that. Or good housekeeping seal of approval. Collective marks, and those would be marks of associations, like AFL-CIO, or accountants. Anything where you have an association that has a trademark. And we look down, sometimes there's just an image or an overall appearance of a product, and you know who made it. Maybe the layout of, I guess you could, if I go into Walmart, and I guess I'm picking on Walmart, the way they have that store laid out, I can probably go to about any Walmart and figure out where to find what I need to find. So that's kind of an example of a trade dress, or how layout. There are some restaurants, when you walk in, you just know that it's a Mickey D or a Arby's or whatever. There's that particular look, that theme. You have trade names, and a trade name basically is what we know that company by, like Kentucky Fried Chicken. That's a trade name. There are counterfeit goods, and we've run across these sometimes when you're doing Amazon or doing internet searches. I think the biggest joke is the Rolex watch and the counterfeits. There's actually an act enacted, the Stop Counterfeit in Manufacturing Goods Act, which makes it a criminal act to copy and sell, or attempt to. And one thing to keep in mind, common law protects trade names. So these don't have to be registered to be a trade name. Common law can protect them. Then we come up to the internet and how things are really being pushed. The envelopes are being pushed because of the internet, and how quickly information is moving around, and how everybody is now an author. But there's something called cyber squatting, which means, let's see, best way to put this is there are all types of domain names out there with different extensions. Somebody might go out and buy up all of the Apple extensions so that Apple Computer couldn't get them all, and then attempt to sell them. That is called cyber squatting. There are laws now that protect some of this. There's the ICANN that oversees the domain name. There's the Anti-Cyber Squatting Consumer Protection Act that makes it illegal to do this. And the last thing you want to look at or think about are meta tags. And meta tags are the words that are used in search engines and that you put in the top of your web pages so that people can find your websites. The best example of this is Candyland. I think everybody knows Candyland is a family game. A pornography site used Candyland as a meta tag, and they received a cease and desist order to stop using that meta tag because children were ending up on the porn site. Then we get to patents, and patents is a grant from the government to give an inventor the exclusive right or privilege to make, use, or sell their invention for a set period of time, and that's usually about 20 years. A patent can protect a product, a process, a design, but not an idea. So patent has to be a product, a process, or a design. About everything, can be a patent, is patentable, except laws of nature, natural phenomena, and abstract ideas. Has to be concrete. And for it to be be able to register, it's got to be genuine, novel, useful, and not obvious, in the current, in light of current. It means you can't take somebody else's invention and modify it slightly and say, oh, this is a brand new item. Can't do that. As of March 13th, March 2013, let's review that. The United States is is a first to file patent award company, meaning the person who files the patent first, not the person who has the idea first, or the concept first, or the process first, but the person who files the patent award first is awarded the patent, which is a little bit of a change. And a patent owner can grant licenses for somebody else to use that patent. Patent infringements, my goodness, basically is making, using, or selling another person's patent product, process, or design without permission. There's no infringement when the product is made and sold in another country, which is interesting, although I don't know how we would ever enforce that. And they may be sued in federal courts, so this is one of those that can also be a tort and a crime. Question. I'm not even sure why that says by. Patents, let's correct that. Patents are protected by which court? State, federal, or Supreme Court only. Then we get to copyrights, and we've got a little short video on copyrights. It's kind of interesting. I think you might enjoy it. Copyrights are the exclusive right of an author to publish, print, sell a product of their intellectual endeavors for a certain period of time. And as you will find in the short video, that's a considerable amount of time. So you have to obtain this, it must be original. It can be music, literary, pantomime, pictorial, a motion picture, sound recording, music, or architectural work. Again, you're looking at, you can't copyright the idea, but the expression of that idea can copyright, such as a novel. They can be registered, and that's registered with the U.S. Copyright Office, as opposed to the Patent and Trademark Office. Here's something that everybody needs to know. This is a myth, and it's called a poor man's copyright. While it is a copyright, in essence, and a poor man's copyright has always been that if you write it and send it back to yourself in an envelope, you've got a copyright on it. Well, in a way, the minute you write something, it's copyrighted because it's yours and it's original. The problem becomes, if it's not registered in the Copyright Office, it's not legally copyrighted, and it cannot be defended in court. Let's see, did I write that wrong too? All one needs to do is send the writing to themselves, and it is legally copyrighted and can be defended in court. No, I didn't. It is copyrighted, but it cannot be defended in court. So if you want something that you can go to court and stop somebody from using it, it must be registered with the Copyright Office. And you have copyright infringements. But copyright is a little bit different in so much as it's a little looser. There's something called fair use doctrine, and that comes down to, let's get down here. Fair use includes, but is not limited to, reproduction for criticism, such as you wanted to, if you're an art critic, or a book critic, or a movie critic, you could show a short clip of a film, or reproduce parts of that book. News reporting, teaching. In teaching, you can use and reproduce work if it's used for the purposes of education or for research. So there's a little bit of latitude when it comes to copyright infringement. Copyrights in the digital form, and this is where things get boundaries get crossed very quickly. Simply downloading a file or a program into RAM, which is just the memory in your machine, is making a copy for the purposes of the copyright law. So one has to tread softly in this. There's a Digital Millennium Copyright Act, and it creates civil and criminal penalties, subject to fair use, again. But it's so easy to copy anymore, and it's so easy to get around encryption, that there really does need to be some revisiting to the Copyright Act. One thing that came out of the DMCA Act, which is what this is that Internet service providers are not liable for copyright infringements. And both of these acts have been really controversial, and they have been revisited in the Supreme Court, which we also have a video about. This one in particular was very controversial when it happened. There was a lot of public discourse about this one. Finally, we get down to something I'm sure you all have heard about, talked about, maybe mumbled about, is file sharing and copyright protection in a peer-to-peer networking system. In particular, sharing stored music files. Napster and Grokster are examples of this. When Napster first came out, everybody was sharing music, and they came up with the copyright laws that stopped it. And they were actually going into colleges and fining students money for doing this. And the other thing would be making a copy of a CD, which many people have done. So there's a lot of new concepts to consider with digital information. And I think that's going to be revisited in the coming years, and maybe even the coming year. Question, true or false, an idea can be copyrighted. We now move to trade secrets, and that's a little bit different than a copyright or a patent. Trade secret is basically things like customer lists, pricing information, marketing techniques, plans, research, development, production methods. These are all things that basically are not registered with a U.S. patent or with a copyright. What they are is they're company secrets. And company secrets need to be protected for competition, to protect from other companies stealing ideas possibly, and getting a competitive edge over you by stealing your methods. So there is a Uniform Trade Secrets Act, and there's an Economic Espionage Act. So it makes the theft of trade secrets a federal crime. Technology, computer technology in particular, has made the protection of trade secrets a very important priority. Now, what is so terribly important to understand is it's very easy now for disgruntled employees to copy trade secrets and take them out the door, or even email them to themselves or somebody else, and nobody know the difference. It's very hard to combat that. So that is one area that has become very, very open and dangerous for many companies. And finally, we have the International Protection of Intellectual Property. There's the Berne Convention. It was 1989. It's talking about copyrighted of any work written by a citizen, and it's first published in its original country, and regardless of the citizenship, it must be recognized by all company or all countries. I'll get it right in a minute, that have signed on to the Berne Convention. There's the TRIPS agreement, and that's 100 nations in 1994. And that's looking at the standards for international protection of patents, trademarks, and copyrights for movies, computer programs, books, and music. There's a few rules and regulations that go with that. And finally, there's the Madrid Protocol, and that's a treaty allowing U.S. companies wishing to trademark its trademark abroad. They can do so with one application rather than just keeping it in the country, our country, and then trying to do it in several other countries. So there is international intellectual property protection. It's still early in the making, though. And finally, true or false, stealing trade secrets can both be a crime and a civil violation. Yes? No? Thank you. I know this has been a lot. This is a long video. But do remember, we're looking at intellectual property, and that intellectual property covers patents, trademarks, copyrights, and trade secrets. Thank you. Be safe on the roads, folks, okay?